You're live.
Good afternoon and welcome to the House Environment Committee. This afternoon, we are taking up S-124. These topics within that bill. We do not have the bill in our possession. And we welcome Jared Carpenter.
Thank you, Madam Chair. Good afternoon, committee. Great to see you all again. For the record, Jared Carpenter, Lake Champlain Committee. I'm here with Scott Sanderson from CLF. I am going to talk about sort of a little bit of background, set the stage for the discussion, and remind some folks of why we're here discussing this bill and what EPA has asked the Agency of Natural Resources to do. And then Scott has some suggestions, some of our suggested changes to S-124. That should be on your website, and a copy of S-124 when Scott gets going, it'll probably be helpful as well because it does go through different parts of the bill. It's not high level, it's more detailed. It talks about specific provisions and also some language changes, but Scott will get into all of that. So I just wanted to just have folks do a little bit of a reminder of a background. I know you have walked through this bill and it's the House version H-146 over various periods this session. But the reason we're here discussing the bill is because of the petition that was filed with the EPA and the EPA's response to the Agency of Natural Resources after their own 2-year investigation, and the criteria that EPA put together for the Agency of Natural Resources that is the basis for 124. We think 124 is a good step in the right direction, but with some changes, it can be trued up more towards what EPA, the criteria that EPA would like to see from the Agency of Natural Resources and AAFM. So I wanted to refer back, and I don't think this has been submitted to your committee in the past, but I'll send it again just so you don't have to dig for it. This is a September 9th, 2024 letter from EPA to the Agency of Natural Resources that was basically their initial response after the petition and after their 2-year investigation. And I think there's one paragraph on failure to enforce and monitor compliance from CAFOs that sort of sets the stage pretty well for this discussion. It says, ANR's delegated obligations regarding the enforcement and compliance monitoring of the CAFO program are not being met. In general, ANR fails to conduct sufficient and timely inspection and fails to take appropriate enforcement actions to deter or mitigate violations. This is because ANR largely relies on AFM to be their eyes and ears on the ground. In fact, state statute codifies a subdelegation where AFM inspects all farms at frequencies determined by farm size. AFM enforces nutrient management planning requirements, and AFM only refers any observed discharges to surface water to ANR. This arrangement often breaks down. Further, ANR lacks sufficient resources to expeditiously inspect farms in response to complaints from the public or referrals from AFM. EPA's conclusions are based on a review of the materials supplied by the petitioners, information provided by ANR and AFM concerning complaints and referrals, and independent inspections conducted by EPA in 2024. It goes on to explain what EPA found to be a broken system. It said, EPA reviewed information from ANR and AFM concerning 113 complaints from February 2021 to January 2023. Based on records examined by EPA, there are numerous examples of ANR AFM inspectors observing discharges to surface water. EPA found that significant number of complaints, 26 complaints or 23%, were unresolved. In addition, despite information in the files, including photos and written documentation of discharges, a large number of the complaints, 51 complaints or 45%, were concluded as no violation found and no NPDES permits were issued. And finally, very few complaints, 7%, were noted as violations of the Clean Water Act. The system that was created that EPA investigated with reliance of this dual jurisdiction and dual inspection frequently broke down and resulted in discharges not being adequately addressed. That was the result of EPA's investigation, and they made a number of suggestions in their January 2025 letter to ANR. EPA suggested that ANR personnel must inspect all potentially jurisdictional farms to determine if a CAFO permit is required. Number 2, ANR personnel must review nutrient management plans and issue CAFO permits consistent with state and federal requirements. 3, ANR must comprehensively track permitting, monitoring, and enforcement actions. 4, ANR must enforce against farms that are discharging without a permit. 5, ANR must have sufficient personnel to fully implement the foregoing requirements in a timely manner. 6, ANR must seek the necessary statutory and regulatory authority to fully implement the Clean Water Act requirements. And number 7, ANR must include a reasonable but expeditious timeline, including a date certain for the completion of a corrective action plan. S124 starts this process and starts fulfilling some of these criteria as required by EPA of ANR. We think it can be tightened up a little bit. And with that, I'm going to turn it over to Scott, who's going to talk about some more details and talk about the suggestions that we have for the bill.
Any questions for Jared Carpenter?
Thank you, Madam
Thank you.
Chair. Thank you, committee.
Do my best to share my screen here. Succeed. Let's see. There we go. Fantastic. Good afternoon, Chair Sheldon, members of the committee. My name is Scott Sanderson. I'm an attorney with Conservation Law Foundation, and I also look after our farm and food program. I also manage the Legal Food Hub, which is a free service that connects farmers with free legal assistance. Like Jared said, I'm going to walk through some of the recommendations that we have on S124 to try to true up the bill a little bit more with EPA's intent and also with ANR's proposed corrective action plan, which they've submitted to EPA in response to EPA's feedback on their bill. And so, broadly speaking, what you'll see on this document, and I see that a number of you have it up, are 8 suggestions. The first 5 are the most substantive, where they're going to suggest tweaks to the bill that I think are quite important. So taking the first one, the first recommendation is to establish an inspection schedule. Now, Jared mentioned that EPA had directed ANR to conduct routine or regular inspections on jurisdictional farms. And the way that EPA described farms as jurisdictional was as animal feeding operations. And that's just a definition under the Clean Water Act that denotes farms or livestock farms of a certain size. And so what we're suggesting here is to add an inspection schedule for ANR that is based loosely on AAFM's current inspection cadence. So not less than once per year for large CAFOs. So any large CAFO or any large farm operation in Vermont. So farms that have 700 or more dairy cows, those would qualify as large CAFOs. Not less than once every 3 years for medium farms, and then not less frequently than once every 5 years for small farms. Now, I want to note here that the definition of small farm operation in S124 does not line up with the definition that is generally used in Vermont. It is restricted in S124 just to farms with livestock, so it wouldn't include vegetable farms. And so while under AAFM's program, all small farms are inspected once every 7 years, when focusing on livestock farms, which generally have a larger impact, it makes sense to make that just a little bit more frequent, bring that to once every 5 years. And now if we work our way down this document, the notes, what you'll find are quotes pulled from the relevant documents that sort of show what these ideas, what these recommendations are truing up to. And so in this case, ANR's most recent proposed corrective action plan, which it submitted just back in March, it committed to inspecting all potentially jurisdictional farms under the Clean Water Act. And that was a response to to EPA's instructions from back in January and also back in September, where EPA said, okay, ANR has to regulate all farms subject to Clean Water Act jurisdiction. And it specified that those farms were all farms that meet the definition of an animal operation and that it needed to conduct routine inspections. And so that's the first recommendation, establish that inspection schedule, but to true the inspection schedule to something farmers are already accustomed to, so that it doesn't sort of upset the rhythms that they're used to in their sort of regulatory experience. The second recommendation is to treat the Clean Water Act as a regulatory floor in the bill and not as a regulatory ceiling. So current language in S124, what it generally does is it instructs ANR to establish a CAFO program that is consistent with and equivalent to the Clean Water Act program and its enabling rules. And that language essentially instructs ANR to try to match the CAFO rules as closely as it possibly can, and denies ANR the flexibility that it needs to adjust to Vermont's circumstances. And so under the way that the Clean Water Act generally works is that the Clean Water Act serves as a floor, and states are entitled to build on top of that floor as long as they meet the minimum requirements. Being able to build on top of that floor allows states to address state-specific conditions. And so, for example, in Vermont, one of the primary area of agriculture that folks will be concerned with under the Clean Water Act will be dairy. That's very different from other states like Delaware, where it's going to be poultry farming. And so the concerns are going to be different, and it is helpful for the agency to be able to basically build on the act in ways that are specific to the industries that are of primary concern in the state. And so you'll see a lot of adjustments here, and basically what it does is it adjusts language so that ANR has to create a program that is at least as stringent as the federal Clean Water Act program, but that it can build on top of that. So that's what these suggestions are going to do. There's quite a few there. It's just basically that the language in the bill you can find in a bunch of different places, and so you have to pull it out in a number of spots there. The third recommendation is mainly to guarantee ANR's independence and to ensure that ANR is able to make independent judgments about when a violation is taking place. So I'm going to scroll down to the little notes section here and just point out, like Jared had said, EPA noted that one of the main challenges in how it has been administering the Clean Water Act with respect to farms is that ANR has relied on AAFM to act to some extent as its eyes and ears, and that it has not been making its judgments independently. And so what you'll see here is the most recent corrective action plan that ANR proposed. It stated that ANR shall be the only entity authorized to determine for Clean Water Act purposes whether a discharge to a surface water is occurring. And it also noted that AAFM will not have jurisdiction over those discharges. This lined up really nicely with EPA's January 2025 letter. There, EPA explained that ANR was to be the only state entity authorized to administer the NPDES program. And for Clean Water Act purposes, it had to be the entity that is determining whether a discharge is occurring and whether a discharge has been fully remedied. They noted that in the history of NPDES regulation in Vermont, the divide between ANR and AAFM has led to confusion in regulatory inaction. Now, the suggestion that goes along with this is to strike from Vermont law a presumption that farms that comply with the RAPs are not discharging. Now, the reason that this is important is that AAFM is the entity that enforces the RAPs and determines compliance with the RAPs. And so if presumptions about Clean Water Act discharges are being made based on compliance with the RAPs, then ANR is being asked, or is in fact being told, to weigh AAFM's decisions when it is determining whether or not a discharge, which is actually unrelated to the RAPs legally, whether a discharge is taking place. And so for ANR to actually exercise independent judgment, its judgments can't be influenced by mandatory presumptions that are based on AAFM decisions. And so that's the third recommendation here, which is to protect ANR's authority to determine whether a farm discharges by eliminating a presumption that contradicts with the Clean Water Act. So that takes us to the fourth, and the fourth recommendation is somewhat similar, except instead of being in an enforcement and determining whether or not a discharge is taking place context, it's in a permitting context. So right now, when farms apply for a large farm operation permit or submit a notice of intent to comply with the medium farm operation general permit, the Agency of Agriculture is instructed to work in, let me get the language right here. is supposed to consult with, essentially to consult with the Agency of Natural Resources in that process. The idea around consultation is to ensure that the Agency of Natural Resources has an opportunity to see the application and determine whether or not that farm does not qualify for a state permit because it actually needs a federal permit. Now, the way that the process is written into law right now, and you'll see some of this in the language that is struck down here. Basically, Agency of Agriculture reviews that inspection and they are supposed to it reviews the application and they're supposed to refer that application to the Agency of Natural Resources if they think that it is possible that a farm is discharging. If a farm is discharging, then it would need a CAFO permit. Now, again, that's another instance where the Agency of Agriculture is making judgments that are in fact jurisdictional to ANR, right? If AAFM needs to decide whether or not to refer, it is basically needing to decide whether or not it thinks a discharge is taking place. The easier way to do this would just be to boost that consultation requirement a little bit and ask ANR to simply make the determination, to simply look at the application alongside AAFM and determine for itself whether or not it thinks a discharge may be occurring. And so that's what recommendation 4 does. It basically requires when these applications come in for state permits for the Agency of Natural Resources to take a look for itself and determine whether or not there is a discharge may be occurring, whether or not a federal permit is in fact required, and not rely on the referral system that EPA has had problems with through this whole process. So that's recommendation 4. The 5th recommendation is to establish clear permitting requirements. I think one theme that we've heard throughout a lot of testimony on this bill is that farmers want clarity, consistency, and fairness. The way that the bill is written right now, it presents a series of circumstances where it basically has negative criteria related to permitting instead of making it clear when a permit will be required. And basically what this recommendation does is it exchanges those negative criteria for criteria that say when a farm will require a CAFO permit. And these basically flip the language that is in the bill right now. So it establishes when a CAFO will need a permit. So when wastes are discharged into waters via a point source, when they're discharged directly into waters that originate or pass over, across, or through the facility. This is language that is very reminiscent of the Clean Water Act itself, Clean Water Act regulations as well, and a precipitation-related discharge of manure. Jared had mentioned nutrient management plans, this 3rd criteria, which is basically written into the bill right now, is a way of getting at nutrient management planning and nutrient management planning violations. Now, I want to highlight that these criteria are essentially what the Agency of Natural Resources proposed in its corrective action plan to EPA. And so those are just noted in the notes for you so that you can compare the criteria that are proposed here with ANR's proposed criteria.
We have a question on this.
Just
Yeah, absolutely.
clarification under recommended, it says, so if you eliminate the words in yellow, it says a CAFO shall be required to have a CAFO permit of the following. Is it if?
Yeah, if any of the following
Okay.
questions, yeah.
If the following conditions are met, so waste are discharged into waters via a point source, so.
Yeah.
Can you help me? I don't understand that because it sounds like we don't want waste being discharged into waters.
Right, exactly. So
Okay.
permitting requirements, so under the Clean Water Act, the Clean Water Act requires any person who is discharging to have a permit.
Yep.
And so this is basically a trigger where the permitting requirement is triggered by the discharge. And if that discharge is occurring, then the farm does need a permit.
Okay, thank you.
Absolutely.
Thank you, sorry.
Okay, so the 6th recommendation relates to S-124 stakeholder process. And it's great to see that there's a stakeholder process in S-124. I think one thing that you've noted is that I think it's important for that stakeholder process to be meaningful in the sense that there is something for it to influence. And I think one thing that the stakeholder process was added to the bill to inform is how ANR and AAFM work together as they deal with their respective areas of jurisdiction. Right now, the way that S-124 is written, it requires the agencies to establish a new, what is effectively an MOU. It's called a document in the bill, but it's effectively an MOU. To establish a new MOU by September 1 of this year. And that would be before the stakeholder group concludes or the stakeholder process concludes. I think it's probably best to leave decisions around the MOU, which I think is the most substantive aspect of S-124 that the stakeholder process is able to inform, to leave those decisions for after the stakeholder process takes place. So this would basically, the suggestion here is essentially to strike language related to the MOU and leave that decision for next year when the stakeholder process can inform it. The seventh recommendation relates to existing programs that S-124 would either change significantly or eliminate. And the first is related to the winter manure spreading prohibition exemption process. So right now, what S-124 would do is it would create a second pathway for the Agency of Agriculture to issue manure spreading exemptions over the winter. Right now, the way that the process works is quite rigorous. I pulled up the RAPs just to show you. What you can see here is that right now, over the winter, farms are not allowed to spread manure on their fields unless they receive an exemption from the Agency of Agriculture. These exemptions are supposed to be issued farm by farm, and farms that seek these exemptions have to submit a fair amount of information to the agency. And you'll see this information here underneath a little bit of highlighted text. The idea behind this process is to ensure that when farms are spreading and when there's an exemption to this winter rule, that it's accounting for all the factors that nutrient management planning accounts for. And so it's trying to create a protective process that allows the farm to get an exemption while still complying with the nutrient management planning idea that if you're applying, what you're applying is not going to end up in the water. I think this is a very well-tailored process. It allows these exemptions to be issued in a thoughtful way that still accounts for farms' needs. And because of that, I don't think that adding a more blanket emergency exemption authority for AAFM makes sense. There's already a very well thought out one, and I think sticking with that makes sense. So I would recommend striking section 5 of S-124. Similarly, their S-124 changes how the small farm certification process works. It basically eliminates the requirement that small farms certify on an annual basis their intent to comply with the RAPs. I'd also recommend removing that part of the bill. It makes sense to have that annual certification. Then we get to recommendation 8, and this relates to the scope of what S-124 applies to. So there's been testimony in other committees with the recommendation that S-124 address only waters of the United States, which is a much narrower category of waters than Vermont traditionally regulates. While I understand that, I think the rationale for this suggestion is that the Clean Water Act, the Federal Clean Water Act, regulates waters of the United States. Again, states are allowed to build on top of the Clean Water Act floor. And so using the more traditional definition of waters that Vermont uses in all its other water quality programs, it avoids a lot of regulatory challenges and sort of jurisdictional fights over whether or not a particular water in question is regulated by one program or another. It also avoids possible sort of strange double regulation problems where a farm that requires a federal CAFO permit may also require an LFO permit or something like that, because the federal CAFO permit, if the definition were changed, as has been recommended, if that definition were changed, you may need two permits to cover all the waters that Vermont actually regulates. So I think sticking to the definition that is already in S-124, which is the traditional definition of waters in Vermont, which is much more expansive than the federal definition, makes things a lot more predictable. It also makes it easier for the regulating agencies.
Do you think there's any downside? The draft we looked at includes kind of both definitions. In the current definition.
If I remember right, I think what it does is it basically combines the state definition and then clarifies that waters of the United States are included within that state definition. I think that's okay, as long as the more expansive state definition sort of sets that outer boundary, I think it's all right.
Members have questions? Representative Austin.
No, I'm just wondering, it seems like this puts a more responsibility on ANR, and I'm wondering if they have the capacity and the funding.
So I think that's an excellent question. The EPA certainly highlighted that as a major problem for ANR. My understanding is that ANR has separately asked for funding and staffing to get themselves started on the CAFO program. I don't know the status of that bill or exactly how much funding or staffing they asked for, but I think it is being addressed separately.
I know they have two positions in the budget. Did you want to add anything else?
Madam Chair, yes, it's, so the governor's request in the budget is in both the House and Senate versions, and it's $800,000 to help stand up the program and funding for 2 permanent full-time positions. I think that's being treated as sort of a start that they'll, potentially revisit in another budget cycle or 2 once they do figure out what the full capacity is.
So it's 2 positions plus 800,000.
One-time money. There's the database, my understanding is AFM has a database, and this will help incorporate it over to ANR. So they're utilizing a lot of the same resources, I think, is the thought process on that.
Okay, further questions for either of these 2 witnesses? Thanks for your testimony.
Thanks so much. Let me stop sharing and then there we go. Thank you.
Steve Collier.
Good afternoon. Thanks so much. Steve Collier from I try to go through pretty quickly, but I'm happy to come back if there are more questions, however you prefer to do it. But what I was planning on doing was just giving a little bit of an overlay of the entire structure, because I think that's often confused, just the way that we're set up in the state, and then talk a little bit about the only change that we do want in the bill is to change the waters in the states, and explain the reasons for that. And then I wanted to talk a little bit, if we have time, perhaps about some of the suggestions that Jared and Scott just suggested to all of you. But if I may, the interesting thing about, well, first, just let me just take a step back.
I just asked that, how much time do you have?
How much time you'll give me, I guess, but I was planning on about 30 minutes or so.
Yeah, that's what we have.
Yeah. So just to take a step back, this is actually an area for us all to be very thankful for what farmers have done and for what all of you have done in the state of Vermont. And when I say that, is this is decades in process, the work that's being evaluated right now. So the Clean Water Act has a pretty narrow focus when it comes to farms. It's Federal Clean Water Act, applies in every state, obviously, including in the state of Vermont. ANR is the delegated entity to enforce that act. But it only regulates discharges, and specifically point source discharges. The interesting thing about farms is that if they're a concentrated animal feeding operation, they can be a point source. So ANR and the whole entire country can regulate farms just like they would a factory. So if you are a point source and you're discharging to waters of the United States, you can't do that without a federal CAFO permit. So that exists across the country, but it's not triggered until there's a discharge. So if you're not discharging, the federal government has no ability to regulate you because the whole point is to regulate discharges. Now, this is where it gets fascinating to me. It's called a discharge permit, but as it applies to farms, you can't discharge. So when a factory gets a discharge permit or a wastewater treatment facility, they get an authorization to discharge a certain amount that's allowable that the state or the federal government has decided is okay in the overall water pollution control scheme. Farms can't discharge. So the trigger for a federal permit for a farm is that you are discharging. And if you discharge without a permit, it's a violation of the Federal Clean Water Act. But if you need to get a permit, you're not allowed to discharge. And so that makes this pretty different than when we're talking about discharge permits typically. Now, there is one exception to that. If you are a farm and you have a federal CAFO permit, you are allowed to discharge in a 25-year, 24-hour flood event. So if you have all the infrastructure that you're supposed to have to make sure that you're not discharging, you do have that allowance to discharge in a big storm. But other than that, you can't discharge. Now, what's interesting is the legislature back in, I think it was 2003, when the EPA first came out with the sort of the latest version of the CAFO rule that's since been updated. But at that time, they recognized that they were regulating, under the Clean Water Act, they were regulating federal discharges, but there was a gap. And that was that if you weren't discharging, there weren't any regulations. So the federal government, the EPA, encouraged states to do more than the Federal Clean Water Act. And that's exactly what Vermont did. So back then, over 20 years ago, the state of Vermont said, okay, ANR has federal government, has the Clean Water Act. It will implement its requirements under the Federal Clean Water Act, but we're going to do more. So essentially what the state did was they extended the Federal Clean Water Act to all of the farms that are not discharging. And so that is the program that was given to the Agency of Agriculture. So it's called non-point source pollution, which just means instead of coming out of a pipe or coming directly from a farm's production area, it's coming in a diffuse manner, often thinking about coming off fields. So basically what the legislature did is they said, Clean Water Act's not enough. So we're going to require farms to do more. We're going to require the Agency of Agriculture to also enforce on farms. Now, the ANR and the Agency of Agriculture do the exact same thing. What we do is we require that farms can't discharge. That's what the whole program is, whether you're under the Federal Clean Water Act or whether you're under the Agency of Agriculture Authority. The whole point of that is farms can't discharge. So no matter which one you're under, there's very slight differences between the Federal Clean Water Act and what we require under the non-point program, but the goal is the same. So what we actually want in the state of Vermont is to have an environment where a Federal Clean Water Act permit is never required because farms are not ever discharging. We're not there yet. Hopefully we will get there, but that's where we want to be. So that whole framework is much more comprehensive than almost any other state. And it's far beyond what the Federal Clean Water Act does. And it exists today. And what's terrific about that, and it's been expanded in 2015 when from Act 64, I think it was 2015, it may have been 2016, but the Vermont Clean Water Act created greater requirements even for farms to meet. But the benefit of all that work that all of you done and that farms have done is that farms are responsible for the vast majority of proven phosphorus reductions for the TMDL and Lake Champlain. That's all work that you created, that you invested in by creating money for farms, that you invested in our agency to help support farms to get there. It's a success story. It's not perfect because nothing ever is, but it is a success story. So we're where we are now because about a quarter of the investments go into reducing farm pollution, and they've every year since it's been counted, they've been documented for over 80%, and most years more than 90% of the reductions. The other thing is farms are ready, willing, and able. They want to jump on board. There are some farms, obviously, who are outliers. There are always some people who are difficult to regulate and don't want to be regulated. But the bottom line is farming groups in Vermont have stepped up to create 3 different farm watershed groups that work to help protect the environment. They talk to us, they talk to A&R, they're engaged in this process. They've been here throughout this testimony. They want to protect water in Vermont too. So it's not a situation where we're having to shake and rattle people. There are always exceptions. But for the most part, people are asking us, how can we do it and can we afford it? It's not, people are not thumbing their nose at the state of Vermont. They care about clean water. They want to be able to produce food and they want to be able to feed us, but they also want clean water in Vermont. So this is a success story. This whole issue with the EPA is not a success story because things were not done perfectly in terms of how the programs were administered. But it's not a water quality issue because whether you're an agency of agriculture or whether you're under A&R, you can't discharge. It's illegal to discharge. The question is which permit you need. So that is what this is all about. If you are discharging, you need to have a federal permit, and that's a requirement if you can't immediately correct it permanently. So I don't want to minimize the importance of the law and that we follow the law. That's obviously very important to do. But none of this is about whether or not farms are being regulated or whether or not farms have to meet standards or whether or not farms are being enforced about. It's a legal question of who regulates what. So we have worked very closely with A&R. A&R has worked very closely with the EPA. We don't want to be in a situation where we're not perfectly enforcing federal law. We agree federal law needs to be appropriately enforced. And if a farm needs a federal permit, they should have a federal permit. Ideally, nobody's discharging, nobody needs a federal permit. But if they do, they do. So, and that's fine. A&R has the complete authority to do that. S-124 is what we've come up with working together. And we really appreciate the work with your colleagues in the other chamber as well. The Senate Natural Resources Committee and the Senate Agriculture Committee worked very closely together. We believe it's an important bill. It got across the finish line kind of late, but people were willing to make sure that it could get over here so we could move forward. We're very appreciative of that. Senate passed it 29-0, which is not 0-1, which is not the most common dynamic when you're talking about issues that both implicate agriculture and environmental issues. So we really appreciate the group support. We really appreciate your consideration. We believe this is an appropriate step so that we can make sure that we're not only enforcing water quality on farms, but that we're doing it in compliance with both federal and state. So as I'm planning, if you're interested, there's 4 provisions in Title VI that you don't come across as often, perhaps, that I was going to explain the basis for rather than going through everything in the bill, but I'm happy to take other questions on what I've said so far if you'd like. Or
Any questions, Representative Bartholomew?
Confused because if I understand it correctly, if you have a farm and you have a point source discharge, you have to have a permit, but you're not allowed to have a discharge.
you got it.
Then what's the permit for?
Well, the permit gives
I mean,
the federal government and A&R the authority to enforce all of the litany of CAFO regulations that come with that discharge. So prior to a discharge, A&R or the federal government has no authority to regulate a farm. Once you have a discharge, or maybe for some things, but under the Clean Water Act, they don't have any authority because the Clean Water Act is triggered by discharge. So once you have a discharge, then you can require a permit and you can enforce all of CAFO regulations are voluminous, but they don't come into play until there's a discharge. But in the state of Vermont, it doesn't matter because farms are already regulated to the same standards by us. I mean, it matters legally, obviously, but the fact is farms can't discharge no matter which system they're under. And so does that answer your question or?
But if there's a discharge, how can they not have a discharge?
They have to stop it. just like they do with us. We,
So the permit is like trying to, it's like a corrective thing as opposed to a permit to discharge.
correct. And that's the sort of thing that is hard to get your head around, because when you think of allowing discharges under the Clean Water Act, you think, well, you're allowing certain discharges, but the whole farm CAFO regimen is not set up that way, except with a 25-year, 24-hour flood. You are allowed in that instance, but otherwise, hey, you can't discharge. Now, that doesn't mean it's easy to enforce, because if you do have a discharge and it requires, a concrete structure to be built and different practices, it may take some time to get that farm into compliance. But ANR would have the authority, or the EPA would have the authority to require the farm, and they would have a compliance schedule where they would require the farm to do it. And if the farm wasn't doing it, they could take more and more aggressive enforcement action, even to the point of, getting an injunction if they had to. So, yeah, but that is the great thing that I think it's difficult to comprehend. Discharge does not mean you can. Discharge means you're now under federal authority and you have to stop.
I guess it's the permit word that's throwing me because it makes it sound like you are permitted to as opposed to what it really means. Okay.
We're not permitted to,
Yeah,
You're not
exactly.
permitted to.
not, and with that, I lost my question, so I'll let you go, Representative North.
Thanks. So a discharge in a normal rain event from a field would normally just not be point source. It would just kind of flow off the field into various ditches and conveyances and whatnot. Once the runoff is in a ditch, is that considered a point source, even if that ditch is like the ditch along the road that's a town ditch?
It all depends where it starts. No, that's a great question. And so basically what CAFO means is production area. When you're talking about the farm, you're talking about the production area. So where you store your waste, where you store your feed, where you have your bunks, where you have your animals, all of those things are considered part of a point source, just like a pipe. So if you have contamination coming from those areas, say you've got an overtopping manure pit flowing into a stream, that's clearly a point source discharge that would give ANR authority immediately to say this is a Clean Water Act violation, and it might give them authority well, they would have authority to immediately require a permit. They also have some discretion, if it can be fixed immediately and permanently, to just enforce on the violation and not necessarily require a permit. But those are decisions up to ANR about how to do that.
Discharge only applies to the operations area of the animal farm?
No. No, it also applies to fields, and to where you spread your waste, but it's a different rubric that sort of dictates that. So nutrient management plans are something so the Natural Resources Conservation Council, which is part of the USDA, has developed a series of standards called 590 standards, just the number of the plans, where they're very detailed, and there's a whole series of things that you have to do to ensure that you are both creating structures that are adequate, and also that you're applying your waste in an appropriate agronomic rate. And I'm not a soil scientist, but essentially what you want to do is apply your manure or your fertilizer in a way that the plants are utilizing it. So it's because you need nutrients or you can't grow anything. So waste and manure and fertilizer are integral to being able to grow things. And the point is to put the right amount on the field so that it's being utilized by the plants, but it's not being washed off. So the way it is for a CAFO is and specifically for large farms, but we don't need to, basically a CAFO, if you are following your nutrient management plan, then that's not a discharge from your field. If you are not following an appropriate nutrient management plan and you have runoff from your field into water, that can also be a discharge that violates the Clean Water Act and can require a permit. So it depends on source, and anything could be a point source. I mean, a CAFO is a point source, but if you separately had a pipe that was, spewing any kind of waste into water, that could be regulated as its own point source. But when you're thinking farm, you're normally thinking production area, which is where the waste is sort of known to be. So that's more tightly regulated. And then fields, where if you're applying things correctly, that's fine. But a farmer can't just use the field that's closest to the manure pit because it's convenient and keep spreading there, because then there's so much phosphorus, nitrogen, everything else in that field, then the plants are not going to uptake it. It's going to run off and you're going to have a problem.
What if a field is tiled, so it's clearly a point source?
A tile is not considered a point source. There are people who disagree with that, but the last time I looked, there's never been a court in this country who's found tile drain to be a point source. However, it is part of a field. So if you are not following your because water,
It's the same as sheet flow off.
water either comes off the top or it drips, goes down and comes out of the tile. So if you are not following your nutrient management plan and you have runoff coming out of your tile, I think that could easily trigger the same requirement if it's coming off the top of the field. But tile drain itself it's not hooked up to a manure pit. It's in a field and people want to make it a point source, but it's not been found under federal law last time I looked to be a point source. And our belief and ANR's belief is that if you are appropriately applying your waste to your field, then the tile itself does not make it a point source. If you're not, then it could still be a source of waste, just like runoff off the top of your field.
Can you describe some other examples of discharges from that production area? You mentioned overtopping a manure storage tank, but what else? What other kinds of things would be a discharge?
So any kind of storage area where you may have you may have fertilizer, you may have pesticides, you may have waste, and you may have often called in a bunk. And if that bunk is not structurally sound and it's running from there down into a ditch, into a stream, that could be a point source discharge. The whole production area, there's a lot of requirements about, first of all, diverting clean water from it. So you don't have just rainwater coming into the production area across your production area and into a stream. So the whole idea is to control what waste you have in the production area, and then also to keep other clean water from coming into it and running off it. So there's a lot of it's really expensive to divert all of this water from the production area to collection ponds, or sometimes it's put into manure pits. But the whole point is really if water is running off your production area and getting to water, it has to make it to water. But if it's doing that, then that can be a point source discharge. So a lot of the resources, a lot of the money that you've appropriated to farms, a lot of that, they very much want to do it. But in case, over 1,000 dairy farms have gone out of business since 20 years ago. And, 32% we've lost in the last 5 years. So money is a real factor. And that money that both Congress and the legislature appropriates to help them with that is instrumental to being able to build this pretty expensive infrastructure. So in terms of the Title VI, I don't have I'm not going to put up a screen. I do have some copies of S-124, but I was just going to refer to S-124 briefly as passed the Senate and just go through it without necessarily looking at the language. But the first one is about vegetated buffers. And if you do want to look at the language, it's on, or I have some copies if anybody wants to see a paper copy.
So we've walked through this with our legislative council.
So, okay. So there's a section and it's in section 2, page 4, line 21. It's about the buffers. And the only reason this change is requested is there are very few differences between federal and state law, but this is one of them. So for a large CAFO, the buffer standard is different than it is under Vermont law. Under Vermont law, a farm needs to have a 25-foot vegetated buffer between their cropland and water, and a 10-foot vegetated buffer between their cropland and ditch. And the whole point is to have this buffer so that nutrients are being trapped in the buffer and not making its way to water. That's the state standard that's been in place for a long time. The federal government does not have that standard. The EPA under the Federal Clean Water Act actually has much more permissive standard in some ways. You don't have to have any buffer at all. You don't have to have a vegetative buffer. You can either have a 100-foot setback, which just means that you don't have to have a buffer, but you can't spread any waste within 100 feet of water, or you can have a 35-foot buffer, or you can have any practice that's approved that's equivalent to the 100-foot setback. So as an example, in New York, they allow a 15-foot buffer along with some conservation practices. I think it's injection of manure and no-till, I think, but I might be wrong about that. But I know the 15-foot buffer is correct. So basically, there's this range of options under federal law that a farm can use in consultation with ANR or with EPA. And if a farm in Vermont were to have a federal CAFO permit, this state law as written would still apply. So it would basically sandwich a farm and would only give them one option, which would be to have the 35-foot vegetated buffer. So rather than pinch them in between state and federal law, we think it'd be much better to give farms the same, if they're going to be, have a federal CAFO permit under federal law, have the same flexibility that federal law affords. If not, then they would still have the same standard that everybody's already familiar with.
You're supporting this change from the Senate.
Yeah, both, everything in S-124 is something that ANR and the Agency of Agriculture have worked together on, consulted with the EPA. Both agencies agree. There is one change that I mentioned, the waters of the US, but everything else in there is something that we work to come together with, support, and we believe EPA supports it. So it's all things that we think are appropriate to get us to the next step. So I don't know if there's any questions about the buffer. So then the next one is section 3, page 9, line 8. It's just a permit fee. Every large farm in the state has to pay $2,500 annually for an LFO permit. This change would make it so that if a large farm is required to have a federal CAFO permit, they wouldn't pay the fee twice. So they would pay the fee to ANR. They wouldn't pay it to the Agency of Agriculture. The LFO permit doesn't just go away because the LFO permit's quite a lot broader than the federal CAFO permit, not in terms of water quality protections, but other things like there's some land use requirements for LFOs that exist, including for some nuisance type activities. And so that the LFO permit would remain, but it wouldn't have a double fee. So that's pretty straightforward. The third one is section 5, page 15. Line 15, and this is the emergency exemption that I think it was Scott, maybe Scott and Jared, but I think Scott was just talking about this. This is not a change at all in existing practice. The only thing, I'll give you a little bit of history for this. The rules that the Agency of Agriculture implements have been in place since about 1985, I think, but they have obviously gotten much more restrictive since that time. Going back to at least 1995, there's been a manure spreading ban in the state from December 15th to April 1st. That was in rule, so in agency rule, before it was ever in Vermont state statute. So in 1995, and I didn't see it in the earlier version, but I saw it in the 1995 version that the ban was there. It wasn't in state statute. In 2013, state statute evolved and created the seasonal exemption, which is that provision that we're asking to amend here. That seasonal exemption is something that never gets used. It's there for farms. They never ask for it. As far as I know, it's never been used, but it is a way that farms can spread in the winter, but it's my understanding is farms consider it too cumbersome. They haven't used it, but it's there. But in the rules, back with the ban that's been there since at least 1995, there's always been an emergency exemption. So that is, if a farm has an emergency, the Agency of Agriculture has always been able to waive the spreading ban so that the farm can deal with the emergency. The best example is an overtopping manure pit. So if you've got an overtopping manure pit in the winter and it's going into a river, you don't want to let that just continue. So you've got to find an alternative solution. So that's what the emergency exemption is. It's been in rule ever since the ban was first enacted. But in 2013, when this new the seasonal exemption was created, the ban was put into state statute, but the ban didn't explicitly recognize the emergency exemption in the rules. So I read that a couple of years ago and didn't like it because arguably it got rid of the emergency exemption that's always been part of the ban and that we've always implemented. So this is we just want to clarify that just like we always have, that if there's an emergency, the same way we've always done it, that we could in fact grant an emergency exemption. It has no substantive change whatsoever from practice, but it is a legal clarification that I personally think is important.
So if I recall correctly, a few years ago, there was a sort of an issue with chronic need at particular farms repeatedly needing an emergency exemption. And so I guess speak to that.
I not since I've been here, I don't think. I think I've been here 5 years, a little over 5 years, and I don't think we've had any chronic examples since I've been here. But the emergency exemption has been, some years it's not utilized at all. Some years it is utilized. We definitely, in our view, if a farm is not managing its manure appropriately, then that's something we can enforce against because they're required to. And most of them are required to have 6 months of storage, which is a lot, 180 days. And so if they don't manage their manure correctly or their other waste correctly, they can create an emergency that perhaps is farmer driven. We have authority to enforce when they're not doing things correctly, but that doesn't mean there's still might not be an emergency that requires a resolution in the winter. We issue it sparingly. We do it with, after consultation. People don't like it. Obviously, we don't like it. We don't want to have to do it, but it's kind of a lesser of two evils. And there's no winter spreading ban in federal law. It's a state creation that was first in our rule that's continued the whole time. And the only time that since I've been here that we used it a lot, and actually we did it under the governor's emergency power instead of under the emergency exemption, was in July of 2023. And that was quite different because the flood was horrible, but also the rain continued throughout the summer. And farmers could have spread during the summer, but their fields were saturated. It would have destroyed their fields. So they came to us and to ANR and said, look, do you really want us out there spreading right now on these fields when runoff would be likely, when it would compact the soils and destroy the fields? And so we worked with them to throughout the rest of the fall, and a lot of them did have issues. And fortunately, we had a great January. And it was actually pretty easy for them to spread, but that was something that was done and a process was set up where there were criteria set in place, and that was in conjunction with ANR and with us. And so it worked out quite well because the weather cooperated in January, not in July. But that was a little different.
Yeah, and then so how does that interact then with the CAFO permit? So you can't have a discharge. That was one of the examples of a discharge. What happens?
Well, that's exactly so we don't want there to be a discharge, and we don't want so spreading in the winter does not necessarily lead to a discharge.
But I'm thinking the emergency.
Well,
They're supposedly calling you before it overflows.
right. It could be ideally they're letting us know before it overtops. If it did overtop, then yes, that could exactly be that. But it could overtop without getting to water and still not be a discharge. But the point is to have the flexibility to make the situation better rather than worse as necessary. But one of our, reluctance in granting the exemptions is we don't want to create a situation where we're creating a discharge by allowing it. So if you're spreading on snow, so we need to look and see where could you spread now at this time? Do you have the field? Sometimes you might have to export to a farm with space rather than being able to spread on your own fields. But yeah, any of these things that create a discharge can be a problem. Now, ANR has that authority if it's not something that's an ongoing discharge to find a violation and enforce it without necessarily requiring a permit, but it can do either. It has that ability to sort of enforce as it feels appropriate. And certainly if it was a third year in a row and someone was doing it, my guess is they would be more inclined to require a permit than if it was the first time and there was a flood that summer.
Right. We do need to be cognizant of the time, and I want you to get to your last request.
Yeah, thank you. So the last change in Title VI is that this is really just an administrative issue, but it's Section 6, page 17. So there's something called a small farm certification. So we have large farms, medium farms, certified small farms, and then small farms. And in the dairy world, which is the most common, a certified small farm means 50 to 199 mature dairy animals. It can also be 50 acres of produce. There's different things that qualify in terms of who's a certified small farm. But certified small farms are subject to the RAPs, just like required agricultural practices, just like everyone else. But they have to tell us right now, every year, they have to certify that they're complying with the RAPs. And that's just administratively for the same farm to file a form with us saying we're following the RAPs every year. It's kind of a hassle for them. And if they don't do it, it's a hassle for us because then we have to, if they're not doing it, we have to get in touch with them, sometimes threaten enforcement, sometimes even bring enforcement to file a form. Ultimately, we care that they're complying, not so much that they're giving us a piece of paper that says they're complying. So we want to know who's come into that category if the farm's gotten bigger and it's a certified small farm. So the idea is just to change the language so that if you're newly eligible as a small farm, you need to file that certification with us. And then the agency would have the ongoing discretion to tell any farm we want to file the certification with us. If we're concerned that they don't know, or maybe they need some education, we can require it, but it just wouldn't make them send us a piece of paper every year. We don't find it helpful. And it's administratively burdensome when farms aren't doing it, which obviously they could just do it, but if we know who you are, sending us the piece of paper doesn't help. So that's the idea. It's just to make it a little bit, give farmers one less thing to do and us one less thing to do that actually doesn't address the water quality issues themselves. So that's it for those issues. And I did want to talk about the one change. So the one request from the agencies, and I apologize that it unfolded this way. When it first was introduced as S100, well, let me back up. The request is to tie federal CAFO to the federal waters of the United States definition. And the reason for that is ANR's program is all based on federal law. It's the federal CAFO program. Our program is Agency of Agriculture's program is all based on state law, which is tied to waters of the United States. So the agreement, the way we navigate, waters of the state. Thank you. So the point is there are no waters of the state obviously need to be protected. We're not suggesting that the farms can discharge to waters of the state, but the whole federal CAFO regimen, as we talked about at the beginning, is all based on federal law. It's the Clean Water Act. And with the Clean Water Act, there's a whole litany of federal CAFO regulations that are actually pretty confusing if you haven't ever read them. But they're all tied to waters of the United States. So that whole regimen is tied to the waters of the United States. We are required, Agency of Agriculture is required to address to non-point source pollution, but also our authority is waters of the state. So waters of the state is usually broader than waters of the United States. Waters of the United States is navigable waters. It's also interstate waters. It's also any other surface water that has a connection to those waters, and including like an interstate pond that has a stream going to an interstate lake is a water of the U.S. And also wetlands are included in waters of the United States, but only some wetlands. So those that have a continuous surface connection to a surface water are waters of the U.S. Waters of the state is basically not wetlands, but any other water. So our concern is something like there are a lot of small ponds on farms, or a lot of small ponds in Vermont that have no connection to another waterway. And we don't think it makes a lot of sense that if a farm still can't discharge to those small farm ponds, and we would have to stop them from doing that. But it wouldn't, to us, it doesn't make a lot of sense to have a federal CAFO permit for a water of the state that's not a water of the United States. So you're basically, instead of using two different regimens, which is federal law here for ANR, state law here for the Agency of Agriculture, you're starting to blend those, and that gets really confusing. It makes the federal precedent a lot less clear because there isn't much precedent in Vermont, if any, maybe on the federal CAFO permitting regimen, but there's a lot of precedent throughout the United States that's helpful. And when you're trying to figure out what's allowed and what's not allowed, it's helpful to go to precedent. If you start blending the definition that actually ties the whole program together, it starts to get confusing to know what that means. I think our biggest clarity is really the sort of the heart of it, and also recognizing there will be zero gaps. No one's saying that a discharge to waters of the state should be taken any less seriously than a discharge to waters of the United States. The only question is that legal permitting issue that we're talking about at the beginning. It's not can farms discharge, who has the authority to regulate them. And so we think it makes a lot more sense for the Agency of Natural Resources to be regulating under the federal program and for us to be doing it under the state program. Now, for the rest of ANR's programs, agriculture is unique in that we're the ones that are regulating farms for waters of the state. ANR has a lot of other programs where they regulate both the point source and the non-point source. In that instance, it makes perfect sense to blend waters of the United States and waters of the state because they're doing it all. But in this case, where we're the ones responsible, ANR is responsible for the federal law and we're responsible for the state law, that blend is confusing. And it also has one potentially pretty deleterious impact on farms. And that is, there's a private right of action under the Clean Water Act. So anybody can sue for a violation of the Clean Water Act, regardless of whether or not they've been harmed. And that's Congress put that in there so that if state agencies or others weren't enforcing the rules enough, it gave other people a right to do that. So that's there. That's not going to change. An individual citizen can file a federal lawsuit under the Clean Water Act against a farm. But to us, it doesn't make a lot of sense to allow someone to file a federal lawsuit against a farm if they're discharging to a pond on their own land that does not have any connection to waters of the United States. So creating this federal CAFO permit for a farm that's not discharging to waters of the United States just gives that a lot more breadth. And it's just another liability that we don't think it's required for farms to have, since they already can't discharge the waters of the state. And that's something that we can enforce on and make them not do it. But we're going to have federal law. Let's implement the federal law in one space and the state law in the other.
So this is a bigger topic that I think we'll probably need to have you back on.
Okay.
But I guess my question is, do you have a map of these waters and how many farms are where related to this ask of changing this definition? Because this is a big change. And I would say one just flag for me is that we currently don't distinguish this way. And so farms are actually used to being regulated for water quality based on the state definition. And this feels like what we've taken testimony on is some of this is like, we want clarification, not confusion. And this ask to me kind of strikes me as being potentially very confusing. And it's ripe for being mapped.
That's a great point. I don't know whether ANR has mapped waters of the United States, but I would say that it's zero change from farms right now, because right now there are no CAFO permits in the state of Vermont. And the Agency of Agriculture regulates every farm to the waters of the state standard. So it's no change in terms of the comprehensive regulation. The change.
A big change.
Well, not from the current. It would just, ANR is presumably going to be issuing CAFO permits. Some we don't, and here's a big issue. We don't know if it's going to be 2 or 20. New Hampshire and Massachusetts are both regulated by the EPA, and combined they have 1 CAFO permit. New York is the 5th biggest dairy state in the country and has 0 CAFO permits. So there's a lot of there's a lot of difference in states and so we really don't know how many CAFO permits, but this would only be that if ANR is going to require a farm, or if a farm wants to, I should say this, farm can always elect to get a CAFO permit if they want to and they prefer. That's their right to do that. ANR doesn't have to approve a discharge if a farm wants to, if they want the protection of the 25-year, 24-hour flood as an example. But if ANR is going to require a farm to get a CAFO permit, this would which is a change from current, they would just have to be discharging to a water of the United States rather than to a water of the state. So
with that, we have a witness waiting.
I'm sorry.
Sorry we didn't have more
No.
time with you. I really appreciate you joining us. And just right now, this bill is in our Ag Committee, expecting it to come out soon, and then will come to us. So we'll see what we get after they've looked at the bill, and I'm sure we'll hear back from you.
Thank you. Well, I really appreciate the time and consideration and for doing this late in the session. Thank you.
Thanks. All right, with that, we do have our next witness is in the Zoom waiting room. So we're going to continue hearing testimony, and then I hope we'll have a break before the next witness. We will have a break. Hopefully it'll be timely. Great. Thank you.
Thank you.
All right, so we are going to shift gears, and we're going to welcome Michael Gauguin. I hope I got that correct. From the Vermont Bond Bank. I just want to remind members that we were interested in learning more after we talked about the housing bill. We wanted to learn a little bit more about what programs were currently available to municipalities to fund infrastructure. And that's what led us to you, Mr. Gauguin. And so we're very happy you could join us.
Thank you so much. Michael Gauguin, I'm the executive director of the Vermont Bond Bank. I respond to anything with that funny last name. So nice to see all of you. Sorry I couldn't be there in person. So I have prepared some materials that I sent to Annika there, and but we'll share my screen. Okay. So and please feel free to jump in with questions. I think this is mostly on background without testimony on a specific bill that's under consideration. But I guess before I start, I'll just kind of give you the oral history of the bond bank. It's kind of a great story and something I think all Vermonters can be proud of. We were the first bond bank in the country back in 1969, 1970. At that time, there was a significant amount of school construction around the state, and the way that the schools were financed was primarily through short-term notes from local banks, a much different banking environment than we have today. And those banks weren't necessarily willing to hold those bonds of the school districts long term. So there was a bit of a capital crunch, and in statute, there's some sort of vestigial reflection of this time, such as bond anticipation notes being able to be rolled over for 10 years. But there was an idea that came that had been sort of circling around New Jersey and landed in Vermont, and that was the bond bank. And I'll get into how we work in a moment here. But basically, since 1970 or 1971, that was our first bond issuance, we've been making loans to municipalities, school districts, villages, any type of unit of government around the state, and I believe have been quite successful. So on to the slides. Who are we today? We, under statute, do have some assignments around in different capacities that are worth noting. The bond bank has a charter member of the Capital Debt Affordability Advisory Committee, CDAC, and we also are part of the local investment advisory committee, two things that have been, I've taken pride in being able to participate in. Then really kind of three main programs. The first is what we call our pooled loan program, and that's the one that was developed in 1969, 1970. That is also the one where the majority of our loan activity takes place. High level, what we do through that program is to pool loans together from school districts and municipalities twice a year. Those local bonds, loans from the communities serve as collateral for bonds that we issue in the wider capital markets that are tax exempt. And our bonds are further credit enhanced through a couple of mechanisms from the state that allow us to receive a great cost of capital. On a S&P basis, we're AA plus, which is equal to the state, and on a Moody's basis, we're AA2, which is just one notch below the state. So we get a great rate. We don't take loan spread from those, and so essentially we pass along that cost of capital to anyone that we've chosen to extend credit to, which could be, a town of 800 or a town of 20,000. And in both instances, they're getting the same great cost of capital. So there's a lot of equity embedded in our process, both from a rate perspective as well as access perspective. And that's what makes it so special. In the 90s, we also became involved in the state revolving loan funds, which this committee is likely familiar with. Drinking Water and Clean Water SRF, that's an EPA match program. The state, through Department of Environmental Conservation, reviews loan applications for compliance with the federal requirements, the various handbooks, and then reviews the engineering side of the equation. When it gets through that process, the loans come to us for financial underwriting, and then we actually the loans are in the bond bank's name. We service them, and then we also manage cash balances associated with that program. So we sort of see firsthand a lot of the capacity challenges of small water and wastewater systems. And then that was kind of what we did up until about 5 years ago, without much modification. And then 5 years ago or so, we started to get more invested in technical assistance. We have an annual capital planning form, and just because we're seen virtually every community in the state that is issuing debt, we started to take our data and learn from it, both in terms of historical activity in a certain segment of infrastructure like schools, but also to share financial benchmarks with communities so that they can compare themselves with relevant communities. And then I don't know if this committee did, but we worked in the town of Charlotte last year and launched last year an energy efficiency and renewable energy program with a dedicated source. We've always done that type of work through our pooled loan program, but found a dedicated source to drive down costs on that. Have done a lot of work on climate recovery from 23 and 24 floods that I'll talk about in a moment. We worked with ANR to receive an ARPA grant, revenue replacement dollars, to help with small water system stabilization. And then most recently, as you all know, we're going to get involved in supporting infrastructure that will ultimately result in housing. And again, that's something we've done historically, but we're anxious to find sources to drive down that cost, make housing more affordable, or make systems generally more financially sustainable. So from a high level perspective, any questions on what we do? Okay, well, we'll have some chances to review some specific examples. So fast forward 50 years from when we started. We've been quite busy, as I mentioned. Last year was probably our busy. Well, last year was our busiest year in our history. We loaned out $200 million to 52 unique borrowers across the state. That includes all of our programs, including SRF. So really quite a bit of activity. Within our bond bank program, so everything we do exclusive of the SRF, our loan portfolio, it's grown a little bit in the last couple months, but as of the end of 2024, it was $617 million. The amounts for local government, 366 million, or 59% of the portfolio, and then 199 unique borrowers. And again, those are towns, villages, school districts, any unit of government we finance. And then in the SRF program last year, 106 loan agreements or amendments that we reviewed and approved. That includes planning loans as well as capital construction loans, and the value of those was about 79 million. As of the end of 2024, that program, amongst all the various buckets for drinking water and clean water, had just under $270 million worth of loans outstanding, bringing the portfolio that we manage as of the end of 2024 to just under 900 million. So here's some examples from last year's activity. I guess before I go on, it's always great to sort of celebrate our staff in moments like these when we are talking about how much work we undertake. We have 4 staff at the bond bank, and that really is only as of 4 or 5 months ago. Prior to that, we had 3 staff. So we run very efficiently and do a lot with a little. And certainly that's something we're proud of because it keeps costs down for municipalities and school districts. Last year, I think the one that's maybe most interesting is the top loan here, the town of Calais. As most folks know, in 23, they had a dam that, there's some pictures of a tarp being laid over it to hold it together. And so we did a couple things for them related to that dam. One was that they participated in our what we call our Municipal Climate Recovery Fund as to receive bridge financing for FEMA reimbursements. But then they also took out a capital construction loan with our pooled loan program of 450,000, a small loan, but speaks to the scale at which we can operate. Anything from a $30 million school district project to a $100,000 say a dam project like in Calais, and sort of everything in between, and do that efficiently. So that's a great example of our work. And then you see sort of the breadth of things that we're undertaking, with the Killington loan being something that was really interesting. We worked with them from the very beginning of that project, significant TIF to support both an economic development project, but also clean drinking water for folks that are on the Mountain Access Road that, there's a lot of PFAS contamination there, and the centralized water system will alleviate some of that exposure. So that loan was ultimately through the SRF program. So I think 3 examples here that sort of speak to the types of infrastructure we're working on. Questions here? Or questions about maybe a project in your hometown?
Well, I have a question about, how often are you financing like wastewater treatment facilities?
Yeah, those are primarily through the SRF program. And there's always we haven't done a major well, that's not true. Shelburne is an example of one that we'll see fairly soon. Burlington, is on the docket as well. We have been working with DEC to develop a robust cash flow model in the SRF, which we haven't historically had, that should allow us to expand, maybe modestly, but nevertheless expand the funding line for SRF finance programs, largely because of those large wastewater projects that are coming through the pipeline.
So those are mostly through SRF, not bonded. You're not using the bond bank to do that work.
For the most part, yeah, there are exceptions to that. One of the reasons we thought the Housing Infrastructure Fund or the Vermont Sustainable Infrastructure Fund was needed is that, as you may know, the SRF program cannot accommodate drinking water expansion. It's really intended to be a repair and replacement program, and so that leaves a gap when you're, obviously trying to develop in new areas that are maybe flood safe for new housing. And so that's one of the use cases for that fund that are pretty important. That also could have come through our pooled loan program. Woodstock is an example of a place where some of the improvements that are needed after the acquisition will be financed through the pooled loan program, that will complement some other SRF sources. For the most part, water and sewer projects are using the SRF, and as well they should. It's a great rate. But there are trade-offs with using the SRF with regard to procurement and the type of, like Buy American Steel, for example, things like that. So it's always a trade-off, and some communities have chosen to use our pooled loan program.
And do you have data on this, like a map or a visual on how many communities? You said you're focused on equity across the size, and is there geographic and a size data available for who's taking
Yeah,
advantage?
and here, if I can, we've just recently updated this, and it hasn't gone live with the updated data, but on our website, whoop, you can't see what I'm doing. On our website, if you go to infrastructure data and then the local infrastructure database, we have geocoded 20 years of data from 2000 to 2020. And this is just in our pooled loan program. It takes a minute to load here, but I think because I'm sharing, it's probably a little bit slower. But the idea here, once this pulls up, is that our capture of local infrastructure projects is quite high. Not just a majority, but something quite higher than that, all come through the bond bank. Therefore, if we're able to, identify and locate our infrastructure projects, it essentially serves as an asset inventory for a lot of communities. And so that was the thinking behind developing this database a number of years ago. And as I mentioned, we've been working with an intern this past semester to bring it up to the current, as well as include some of our SRF data. The point locations are not for the projects themselves. It's mostly for the town. But you can sort of see what's located, roof repairs and renovations in 2005 for the Orange Southwest School District. So that's where you can see sort of what we've done.
That's great. I'm so glad I asked that question. Hopefully you can send us that link.
Oh yeah.
Yeah. And I have another question. You said we're currently a AA rated bond. What would it take to get us back to AAA rating?
Yeah, I mean, so big picture, we follow the state's rating. We have two forms of credit enhancement for our bonds, and can go as deep on this as you want. But one is if someone doesn't pay us, we can offset state aid due to them to backfill debt service payments. It's very common, like if you have if you work with USDA or somebody like that, they would do the same thing. If you don't, pay USDA, they would offset it with any other federal transfers due to you. So we've never used that, but it's a very powerful form of credit enhancement. And but those state aid payments are obviously based on the ability of the state to make those state aid payments. So therefore, our rating is a derivative of the state's. So back, boy, geez, I guess it was like 7 years ago at this point, the state was downgraded. And that was really largely due to demographic challenges that everyone, most policymakers are well aware of. And so that's really what you're fighting against in terms of upgrading the state's rating. Now, the rate difference between a AAA and like a AA plus is pretty marginal, really. So it's not like we are, it's a fraction of a percentage point. So it's not like we are materially losing borrowing capacity because of the rate associated with that difference in rating.
Thank you. Representative Austin.
Yeah, I just have some questions. I saw water up there. Does that include wastewater treatment plants?
Oh yeah, yes.
Okay, and just how, can local option taxes be used to pay off the bond?
Yeah, when we're looking at water and wastewater systems, the way we evaluate them from a credit perspective, and here I can take this down. So I've got more good things to share, but when we're looking at those enterprise systems, even though with limited exception they are general obligations of that community, we really look at them as what's called self-supporting or self-liquidating. So we look for the user fees and the charges to service both expenses as well as debt service. And so what we don't, we like those systems to be sort of self-supporting so that they don't need transfers from the general fund, which is typically where the local option taxes would go. Now, on some of the startup programs, such as like Montgomery, they are looking at local option taxes as part of the financing mechanism, and that makes sense in a lot of ways. It's a startup. They don't have a track record of rates. They are, need some sort of supplementary source of revenue until new users are added to the system. What we have seen more generally is those local option taxes be a great way to support infrastructure in a number of different communities, and it certainly seems to be working well. So to answer your question there, but if there's a clear story as to why the local option taxes are being used for an enterprise system, we get comfortable with that. We just don't want the system to need subsidy to exist. Generally, we're looking for it to be, like I said, self-supporting from user fees.
Thank you.
So a couple more things to share here that I think the committee will find of interest. In a nutshell, this is what we're doing. We're taking capital from either the capital markets, the state, federal sources, packaging in a way such that it's digestible to our local communities, creating standard form documents, creating timetables and relationships that are understandable, trustworthy, and can be relied upon, and then therefore getting really good responses to using our programs, so that the local communities don't have to sort of start from scratch in terms of their learning. And there's a huge opportunity cost savings associated with that, as they don't have to, a new town manager, a new finance director doesn't have to become educated on the complexities of the municipal bond market, for example. And so, yeah, kind of stole my thunder there, but some of the advantages of a state bond bank are, I mentioned the equity aspect of it, which I think is just really amazing. There's also implicit diversity or diversification in our portfolio. So, hard hit communities in the central part of Vermont responding to the flood are going to get, low cost capital to rebuild and adapt and be resilient alongside those communities that were not hard hit. So that's a real advantage. I mentioned reduced opportunity cost to accessing financing and reduced time required. We have workforce challenges across the country, government finance officers are increasingly hard to come by. And even someone might have a great, really solid corporate finance background, but they might not understand the complexities and the nuances of a really peculiar municipal bond market. And we distill that down, have market expertise, and make it, as I said, really palatable for local communities. They've got form documents. We handle all the complex reporting requirements on our end, and then they just have a trusted relationship with the local entity like the bond bank. I mentioned federal resources. Our energy and efficiency and renewable energy program was sponsored with a $40 million loan from USDA Rural Development. And it's a great program where we get the loan wholesale at 0%, and then we re-lend it for energy efficiency and renewable energy programs at a very low rate, around 2%. And that's a great example of taking federal resources and distilling them down in a way that works. Also, sometimes federal grants require a match, and the bond bank can be there with efficient and low-cost capital to make that federal match. And then finally, as I mentioned in our kind of newer activities, we're responding dynamically to on-the-ground challenges as they arise, and can take our market and financing expertise and shape those programs in a way that makes sense. And so on that note, I thought I'd spend just a moment to talk about our post-flood work starting in 2023. I've been at the bond bank for 8 years, and starting, when I looked at my first financial statement in 2018 up until 2022, I was seeing unresolved costs from Irene on essentially on the balance sheet of local communities. In 2011, post Great Financial Crisis, there was depressed lending activity. Municipalities were kind of were just a great way to lend money for banks. Also, it was a depressed loan, interest rate environment, and so the cost of rolling over that debt was not particularly expensive. Fast forward to 2023, and the rate environment was much higher. There's probably different risk assessment in terms of the rollover risk of renewing a short-term note to bridge FEMA reimbursement. And so coming out of that experience, we really thought that a medium-term lending facility, 5 to 7 years, was essential to give communities breathing room to bridge the FEMA reimbursement process, to make the right decision about how they wanted to rebuild. And that intuition has proven to be, unfortunately, quite true. I'm sure you've read headlines about the potential for FEMA. That's not so much going to impact the 2023 impacted communities, but the 2024 disaster certainly is already demonstrating there's already some indications it's going to be a slower obligation process than was 2023. And so having that flexibility has proven to be really helpful. So we've done three rounds of this program that initially was developed with through a great working relationship with the state treasurer, who lent us from the 10% in Vermont program dollars that we then relent to flood impacted communities at the same rate, so 1.3% for 7 years, 2 years interest only. And that was really well received, about 2 times oversubscribed for what was initially a $15 million financing round. We then kind of repeated that process after 2024 floods with money we temporarily used from ERAF. And then within the next couple of days here, we're going to do another 2024 loan with the same facility from the state treasurer. We're using repayments in that program to relend, and then a little bit of additional capacity as well. So we don't think this is going away, this need. So we're exploring ways to try and make it permanent and potentially grow the program. And then here's a great example of federal assistance being matched or mixed with unique programs of the bond bank. Charlotte Town Garage burned down a number of years ago. Voters decided to rebuild it with a bond. The pooled loan program we have rebuilt the structure. Our special energy program helped to finance the solar panels. And then that program will receive a refundable tax credit from the IRS as part of an IRA provision. And the bond bank was sort of along the way, making sure sources and uses were well matched and sized appropriately for what is ultimately a pretty small project in the grand scheme of infrastructure financing. So real uh, uh, a great story here that we're anxious to, or that we're starting to repeat around the state. And then finally here, I think this is sort of what prompted some of your questions, but the Vermont Sustainable Infrastructure Fund that we're hoping to have passed, we are going to use that through, we're going to kind of use our expertise with thinking about ways to optimize capital for, for the small communities, we'll make direct loans, potentially drinking water expansion, potentially some sort of smart growth principles with regard to transportation improvements. And then in some larger projects, we might use some of the dollars to bring down the cost of capital through our pooled loan program and kind of mix sources in a way that makes sense for local communities. And then we might also be able to use the sort of corpus of that fund to further guarantee projects and make them credit worthy when they otherwise wouldn't be. So we're anxious to get to work on that and do some creative structuring. So those are all the materials I have. I'd be happy to answer any other questions I might not have covered at this point.
Can you just expand on that last thing you said, to enhance projects that might otherwise not be eligible for funding? That sounds a little off to me.
Yeah, there are here, let me stop my share here. Yeah, there might be instances in which probably just the larger projects that are more sophisticated. As the CHIP program stands right now, this likely will not be necessary. This idea was sort of developed when there was potential for projects to be not general obligations of a community. In which case, if you had a more limited credit structure or revenue stream, from just the project itself, we thought this would be a useful way to potentially credit enhance those projects without having to lend out dollars. But that probably is not a use case, at least after this session, that will be relevant. But certainly the other two will be. The point being, this fund is very flexible, and so we'll be able to, within the confines of the statute, we'll be able to put it to work in a way that meets the needs of the project, and that's what we're happy about. Because if we're just lending dollars that we're then relending, that's very efficient from a deal execution perspective, standardized documents, but there's not a whole lot of flexibility to take any kind of risk that is unusual, or to structure things in such a way that is unconventional in the market. And having equity dollars like we do in the SRF can be really useful for small communities, for small fire districts, things of that nature.
Representative Norris.
Yeah, thank you so much for your presentation. This is very helpful, Michael. What criteria are there that or income levels, or any criteria like that for a borrower to be able to come to the bond bank and start the sort of loan process? And how does that differ from, say, the CHIP program, where there are some criteria that you have to meet to participate?
Yeah, in general, we have these programs that I kind of described that are special uses for like energy efficiency or will be housing related. But in general, one of the things that makes the bond bank so great, particularly our pooled loan program, is that there are no limitations on the uses of funds other than general best practices like asset and liability matching, that you're not taking 30-year debt for a piece of for a computer or something like that. But like we sort of follow borrowers where they need to go, and that's proven really useful. One of the anecdotes I like to describe to folks working on climate issues nationally is one of the funny things about the most resilient infrastructure investment we helped a community make was that it was gravel pits that, you know, where a lot of the damage was post flooding was in roads, municipal roads. And so having ready access to gravel was like really helpful for communities to rebuild quickly and get people to work and school and wherever they needed to go. And you couldn't really, I mean, I can't imagine a federal program you would design to prioritize gravel pits. You know, it's very unique to a rural place, and but that sort of plasticity of the bond bank infrastructure makes it work. So then we're less concerned with the projects other than basic asset and liability matching. What we're really looking at is you know, that communities you know, we're looking at their creditworthiness like any other lender. Since we're a public lender and we have the state intercept, we're not really risk rating and asking folks to pay a higher spread based upon their credit. We're really more binary. And there have been times where we say, hey, you know, I think you need to work on these 4 or 5 things and come back to us. Mostly that's in the water and wastewater systems where they are undertaking a project and don't have the rate structures sufficient to service both expenses and debt. And we say, you know, you really need to get that rate structure in order so that you can pay debt service when the time comes, and also accommodate unforeseen repairs that might occur in the system. So those are the types of analysis we're having, and that's why we've become really intimate on small water systems and understand this to be a point of vulnerability for the state, because we are like all those SRF loans, like I mentioned, we looked at I forget how many, but you know, at least 70 systems that we looked at, and oftentimes had hard conversations about the need for rate increases prior to the project coming online. So that's how we, you know, that's kind of what our process looks like, high level.
Thank you.
All right. Thank you so much for this. It was very helpful. We appreciate you joining us today and sharing this.
Yeah, very welcome. Thank you so much. And I'll send this link to the map, and please feel free to reach out with questions as they arise.